I'm gonna let Randy Johnson, our attorney, come in and take over, guys. Thanks for joining in.
Good morning, everyone. Welcome to our first day of summer. We'll spend it in the classroom. Mark had asked me earlier to put out some kind of bulletin for the FIRPTA class, and I told him, well, Mark, FIRPTA is not a real exciting topic. I don't know if I can come up with something that's going to get anybody real excited to be here, but here it is, and this is our topic for the day. Just for a little background, so the purpose of FIRPTA, what FIRPTA stands for, is that it's the Foreign Investment in Real Property Tax Act of 1980. It's designed to allow the IRS to collect funds from the seller on a transaction where they may not be a U.S. person. The theory behind it is that they were losing some of that revenue because the people or entities were selling their property, going back to their home country and never paying any tax on it. So in order to cure that, they of course made the buyer the responsible person. So, and it includes, just so you know, that before we skip to the next page, it does include any transaction that involves any interest in real estate. So it's not just a total sale. It can be a contract for deed sale, a short sale, or deed in lieu of foreclosure. Anything that involves any interest in real estate is considered a FIRPTA transaction. And then if we go to the next page, the buyer is the withholding agent. So the buyer is burdened by the IRS for the responsibility of paying that tax. So if that tax isn't collected and the IRS learns of the transaction at a later point, and the question arises of whether or not the seller had any responsibility to pay taxes on that sale, there was a capital gain there, they're not going to go after the seller, they're going to go after the buyer. So, and that is problematic for the buyer most of the time because they don't realize it. So the FIRPTA regulations require the buyer, unless they follow all the rules and get all the documentation that we're going to talk about, they have to withhold 15% of the property sale price, not the amount that the seller's realizing from the sale, but 15% of that sale price. If you have a $300,000 sale, they've got to withhold $45,000 and send it to the IRS with forms 8288 and 8288A, which is fairly similar to a 1099 form, but it's 8288 and 8288A are the designations that those forms get, and that's where it's reported. On that form, it's going to ask who's the withholding agent, and the withholding agent is the buyer. So I'm going to scroll down a little bit. There are any exemptions that for that withholding, and yes, there are several exemptions. One of them involves one of the forms that we talked about. So if the buyer receives a certificate of non-foreign status, which is basically the seller's FIRPTA affidavit containing the seller's taxpayer ID number, or a qualified substitute statement, which appoints the title company to be that agent for the seller, so they don't have to give up their tax ID number to the buyer, because that is problematic as well. Then that statement will also contain that affidavit. The seller provides a notice of a non-recognition transaction. A non-recognition transaction is one where there's not going to be a tax liability. That has to be determined in advance. Typical would be like a 1031 exchange, or maybe some kind of a stock transfer, but very limited, and it needs to be determined in advance. And the seller's got to provide the notice to the IRS that it has been approved as a non-recognition transaction. So it takes some planning on the part of the seller in order for that to take place. The other exception that can be dealt with at closing is if the property is acquired for use as a buyer's residence, it can be exempted from that withholding requirement. And we'll kind of go through that later because there are some steps and some some affirmations that the buyer has to make for that to be the case and to be an exempt transaction then. And the other one is the buyer receives an IRS withholding certificate stating that no withholding is required. Those, again, take some planning on the part of the seller, because the seller has to apply for that withholding certificate and then give that information to the buyer, so the buyer can then get that exemption from that withholding. There are some other limited exemptions that may apply to certain sales, but they're going to be very, very infrequent. And, you know, they're best things that are talked with the tax accountant. So what is a foreign person? The foreign person does not mean that that you have to be a U.S. citizen to be a U.S. You don't have to be a U.S. citizen to be a U.S. person. So a foreign person is somebody who's not a U.S. person, but a U.S. person does include some foreign persons, aliens who hold a valid green card is one condition. So that's the easiest condition. So if you have a U.S. citizen, they're automatically going to not be a foreign person. And if you have a resident alien that has a green card, they're also going to not be a foreign person. If you scroll down,
Is there any, can I ask one question? Is there any price point limit for someone that holds a green card? Are they capped at any dollar amount, or is it
well,
the
again, the
same
green
as
card,
anyone else?
a green card holder is exempt from the withholding. So they're not capped out, you know, so there's, yeah. So just by the virtue of having a green card, the FIRPTA withholding doesn't apply. Okay. And then if we scroll down a little bit more. So the determination of whether that applies is not really made by the title company or the closing agent or the real estate agent. It's actually made by the buyer. The buyer is burdened with that responsibility by the IRS. It's often the agent and the closing agent and the title companies that are talking to the buyer. But again, none of us, real estate agents, yourselves, closing agents, title companies, should be giving that buyer tax advice. So anything that you say to them regarding FIRPTA, you should always encourage them to talk with their tax attorney or with their tax accountant to get further advice. But it's often just those conversations the buyer will base his decision on. So in August of 2015, the Realtors Association, even though this is a 1980 law, not until 2015 did there get a statement added to your purchase agreement. So typically we'll see that come in unchecked, but it's really going to apply whether it's checked or not. But go ahead. Someone have a question? Okay, I'm sorry. So anyways, on that purchase agreement, there's a section there that just says the buyer and seller agree basically to apply to the FIRPTA guidelines and the FIRPTA requirements. And they're really required to do that anyways by law, because again, the law has been in force since 1980. It's become more prevalent since 2015 when it became part of the purchase agreement. But at that point, as agents, you should begin discussing FIRPTA with your clients and make them aware that they have some FIRPTA documents that are going to need to be executed and taken care of at closing. The first one is that certification of non-foreign status and your qualified substitute statements, which really become the seller's affidavit. So on that statement for the seller, they have to certify that they're not a foreign person, meaning that A, that they are a U.S. citizen, or B, they have a green card, and give up their home address, their address of the property sold, and their taxpayer ID number and their legal name. So those are the requirements that are be on those forms. The seller doesn't like to give that tax ID number to the buyer all the time, so they'll appoint someone to be their qualified substitute, typically the closing agent or the title company. That qualified substitute statement will have that information on there. But the seller will assign that qualified substitute statement. And then that closing agent or that qualified substitute, if it's somebody other than a closing agent, will provide that information to the buyer. Okay, which then may not contain the taxpayer number, but it contains the certification to the buyer that the qualified substitute is going to provide that information and retain it for the required 6 years. So the question becomes, if the seller discloses to the buyer that he's a foreign person, is that going to protect the buyer from that IRS liability? And the answer to that really is no, because the buyer has to prove that he was informed of that. And the only way to do that is with the CNFS or the QSS forms, which are really the seller's FIRPTA affidavit. And that's why you want to document that for every transaction. And then want to scroll down again a little bit. And again, I just talked about this a little bit. So must the seller provide his or her social security number to the buyer in order to be exempt from withholding? Again, it doesn't have to provide it to the buyer because they don't always want to reveal that information. They don't know what the buyer is going to use it for. And that's the purpose of the qualified substitute. They provide it to the qualified substitute. The qualified substitute retains that information, indicates to the buyer that it's going to retain it for the requisite period of time, and they provide all that information at closing. The next question, it says, can they provide it to the title company only and not to the buyer if the seller does not provide a QSS? And basically, if you read through that paragraph, basically what it's saying is there's not really any prohibition against that in the IRS regulations, but there's not really any authorization for it either. So, it's a rolling the dice, and typically I never advise anybody to roll the dice with the IRS because you're probably going to come up on the short end of the stick. So it's best to provide either the CNFS or the QSS, one form of that seller affidavit, because you're protecting that personal information for the seller, and the seller doesn't have an issue with that then if they're providing that QS form. And if we want to scroll down a little farther. So what form of CNF may be used by a non-foreign seller? So basically the issue there is, what's the definition of seller? The seller can be U.S. resident, can be a U.S. resident alien. They'll use the same form. It's called an individual CNFS and certification of non-foreign status. But on that form, you're going to select either that you're a U.S. citizen or that you have a green card. Or there's another selection on there, which we'll get into a little bit later, but the other method is what's called the substantial presence test. And I don't want to get into that right here. We'll get into that a little bit further down. The other thing to bear in mind for number 3 and 4 is that we have situations where there can be an estate or a personal representative or a trust or a trustee uses a little bit different form, but if those entities are a non-recognition entity, so for instance, they don't have a separate tax ID number, they're using a tax ID number of the individual, they're going to go and look at that individual status of the trustee, of the personal representative, or of the deceased party to determine if that party is the non-foreign seller. So you could have a trustee or a trust that's created in the United States that's a non-recognition trust, meaning it doesn't have a tax ID number, that has a trustee then that is a foreign person because they're not a U.S. citizen or have a valid green card. And that is going to be a situation where the buyer has to withhold, because that trustee then becomes the withholding person for the purpose of that IRS regulation. The same thing happens with entities. So if you have a limited liability company where you have a sole member LLC, that sole member LLC is considered for tax purposes to be a disregarded entity, even if it has its own tax ID number, but it's disregarded because it all passes through directly to that sole member. So if you have an LLC that's formed in the state or somewhere within the country, but the sole member of that LLC is not a US citizen or green card holder or passes that substantial presence test, that's still going to be a situation where withholding applies, and that 15% is going to be withheld. One exception to that, if that sole member LLC is made an election with the IRS to be treated as a domestic corporation, which they can do by filing a certain form with the IRS, then that sole member would not have to, but they'd have to prove that they've provided that certification to the IRS. That I think we just skipped over it, but it says how many years should we withhold it? And that withholding is for, it's required to be held for 6 years. And so if a foreign corporation, so again, the foreign corporation, the best if you're a corporation to talk to your tax advisor, because there's a lot of different ways that you can set up your corporation. And if you're a publicly held corporation, there's not going to be a requirement for that. Withholding, they can be subject to withholding in other matters, but again, a corporate seller needs to discuss that with their tax accountant and make the elections and make it known to the buyer and provide the buyer with the withholding exemption based on their status before that's not going to apply. Because if we don't have that exemption and notification, that 15% withholding is still going to apply. So what happens if the withholding doesn't take place and the buyer and the IRS gets later determines and sends notice to the buyer that we've determined that this was a capital gains transaction, that there was liability on the part of the seller for taxes on that property, and you fail to withhold at the closing, they can withhold full 15% of the property from the sale price, or not, excuse me, withhold at that time, then assess that 15% to the buyer as a taxes due from the buyer to the IRS for that 15% that wasn't held at closing. So again, that's one of the reasons you don't provide information to the buyer as their tax accountant or tax consultant, because the liability is very high, and the buyer needs to make his decision based on whether or not he's comfortable with the representations made by the seller in those FIRPTA affidavits. What's the liability of the agent? An agent can be liable if the IRS determines that any information that was given to the buyer was not factual or represented properly, and the agent knew or should have known that some of that information was not complete. The agent can also be held liable for that 15%, and they'll get notification from the IRS as well. So if you're reviewing information with the buyer and you know that some of that information is incorrect, you want to make sure that that buyer is aware that that information is incorrect. Jordan, if you want to scroll down a little bit more. So is the buyer protected from personal liability if the information on forms are false? Again, I just alluded to that a little bit. So if the forms are false and the buyer had knowledge of that falsification, then the buyer is not going to be protected from liability. But if the buyer reasonably relied on that notice and all that information turned out to be false, but the buyer was not unreasonable in relying on that information, so he did so in good faith, that information is going to protect him from liability. But again, he needs to have that information on those seller affidavits, and he needs to be able to show that that was reasonable for him to believe that information was correct. So what if the buyer learns of it after the sale? So that's only going to protect, those forms then are only going to protect from the buyer for consideration that's already been paid. So if you have something like a contract for deed situation where there's money still coming due to that buyer from the seller, it doesn't apply for any money after that buyer receives notice that that seller is actually a foreign person. So from that point on, the buyer would be responsible for withholding that 15%. And it could mean that, for each one of those payments that come in, you've got to send an 8288 and 8288A and send 15% of that to the IRS. Again, we talked a little bit about this, a notice of a non-recognition transaction, so very limited. I did mention the 1031 exchange. Another one would be a U.S. tax treaty situation. Any one of those non-recognition transactions, is going to be something that you want to talk to the tax advisor on and not get involved in it too personally as the agent or even as the buyer, because it's going to be too complicated. But we do need to have notice from the IRS that's a non-recognition transaction. So I'm going to scroll down again a little bit. So there are some exemptions, and one exemption that is probably one of the more frequent exemptions is when you have a transaction that is from $0 to $300,000, exemption subject to an IRS residency requirement. So if it's less than a $300,000 sale, the buyer can affirm that he's going to remain in the property, he's going to use the property as his homestead, or a member of his family is going to use the property as homestead, and he's going to remain in that property for at least 50% of the time during the next 2 12-month periods. So that means not for the next 2 years, but to the 2 next 12-month periods. So it wouldn't be, if I close today, it wouldn't be for the year 2021 and the year 2022. It's going to start, that 12-month period is going to start tomorrow and then continue for 24 months. And it can't be an accumulative number. It's got to be 50% of each one of those 12-month periods. So you can't be 49% in 1 year and then 51% in the following and still claim the exemption. So the reluctance for buyers to make that certification can be based on their intentions on the property. So if a buyer isn't sure how long he's going to live in the property, if he's buying it for investment, he's going to flip it over, he's not going to make that certification. So even in those transactions that are less than $300,000, you're still going to be subject to that withholding. And there is a form there for the buyer to make that certification. But again, that form has to be signed and presented, and the buyer has to agree that he's not planning on changing his mind during that 2 12-month periods. And
so, quick question: when you read the IRS forms, it talks about vacant days not counting against it. Can you please explain that? How the vacant days?
Yeah. So you can't.
Into that?
Yeah. So basically, if there's any of the days of where the property is vacant, then those days don't account into making that determination. So you have to use the days that the property is useful. So, but you have to then, if you have days where the property is vacant, then you have to make some kind of certification to the IRS. This is the reason it was vacant and why it was not useful during those days. Okay. Does that make sense? And we want to scroll down a little bit more.
Yes, thank you. I'm just trying not to interrupt. I'm going to hold my questions to the end.
No, interruption is fine.
I've actually had that vacant days one come up.
Okay.
And I always ask that they have a CPA provide a letter
exactly.
to the buyer.
Yep.
I've literally had to have a condo sit vacant for a year so that the vacant days didn't count as IRS not being their days.
Right.
And I never quite understood
And you know, and the IRS is
that.
they're very exact in their calculation of days and time. So if it says 50 days, 50% of the days that the property was useful during that 12-month period, they're going to want a calculation of those days, and they're going to want to divide it in half. And there's not going to be any leeway. That's what I'm saying.
Yeah, so the condo that I'm thinking of, the seller did a massive remodel that took up a share of those days.
Yep.
And so it was vacant during the remodel, so those days were exempt.
Right.
And really, they lived here very little of passing the test.
That they were vacant and it was unuseful, and it's best to get the tax attorney or the CPA involved at that point. So. Okay, we want to scroll down a little more. So if you have a buyer, obviously that next question is that if that question doesn't apply, then the full FIRPTA withholding is required. So if there's a sale $300,000 or less, and it's not going to be used as a residence for the buyer or his family, then the FIRPTA withholding, the 15% is going to apply, and you have to send that 15% in. So one of the other exemptions was a withholding certificate, and as I said, that takes some planning, because one of these other questions, I'll get into it later, but you only have 20 days after closing to either send that money in or show the reason that you didn't. And a withholding certificate is something that has to be applied for with the IRS, and the seller's got to apply for that withholding certificate, provide it to the buyer, and the buyer's got to present it to the IRS and say, this is why we're exempt from withholding. But you're not going to get an answer from the IRS in 20 days. So if you do it on the day of closing, you're not going to have that withholding certificate within that 20 days, and that 15% is going to have to be sent in anyways. So, go ahead, scroll down again. So there's 6 different categories that apply to that withholding certificate. We've talked about some already. Your first one is your non-recognition treatment or your exempt status. And again, you're going to have a CPA or tax attorney involved, and there's some planning ahead of time for that. Calculation of seller's maximum tax liability. Again, the seller is going to make that claim based in the withholding certificate based on their own tax situation, but you still need, as a buyer, you need that certification from the IRS to not withhold. Again, the same thing with installment sales. The same thing with the tax conforming security. And then there's also what's called a blanket withholding certificate based on some other form that the seller has convinced the IRS that they should not have to pay taxes. But again, it takes some planning, because that seller is not going to get that withholding certificate in that 20-day period from closing and when the money's got to be sent in to the IRS. So the parties definitely need to talk to their tax advisor or tax attorney in advance. So if you have a seller that you know is a foreign person that doesn't feel that they need to pay that 15%, you need to have them start that process early on, because it's going to take more than 20 days. So you want to scroll down again? So again, that first question just kind of reiterates what I just talked about. So you've got that 20-day period, and that 21st day, that money's got to be at the IRS, or there's going to be penalties that are incurred by the buyer, possibly the closing agent, title company, and anyone else that's involved in the transaction. So the next question is, when are the funds withheld? And again, the funds are withheld at closing. It can be delayed for that 20 days. You know, if for some reason to believe that there's going to be withholding certificate that's going to be produced within that 20-day period. But again, if it's not produced during that 20-day period, the obligation of that closing agent then is to submit that money to the IRS. And that's again on the 8288 and 8288A, which are forms that I don't really need to explain to you, but they're very similar to a 1099 form. The buyer is listed on there as the withholding agent, and it'll show the agent for the buyer as the closing company. So this is one of the more common problems with FIRPTA that you see is you have a seller that's entitled to the property, and he's got a married, he's married, he's got a spouse. He or she has a spouse that is not entitled and also not a U.S. citizen or a resident alien or can pass a substantial presence test. The IRS, whether or not you're entitled to the property or not, treats anybody in that marital relationship then to have a 50% interest in the property. So that 50% interest of that non-title spouse would still be subject to that 15% withholding. So if you had a $400,000 sale and just the wife was entitled to the property and the husband was not a U.S. citizen, not a green card holder, and not substantially present in the United States, there would be $200,000 of that sale that would be subject to the withholding. And again, not half of the sale proceeds, but half of the sale price itself. And again, I talked about that early on, but the FIRPTA require withholding at a foreclosure sale or by a lender accepts a deed in lieu of foreclosure. Again, the answer is yes. Any transfer of a real estate interest is subject to FIRPTA requirements. And again, these types of situations take some planning in advance by the seller, because typically in those situations, there's situations where there's not going to be any money going to the seller. So in order for the seller to withhold or be exempt from withholding in those types of situations where there's actually no funds available for the withholding, they have to get that clarification from the IRS, that withholding exemption certification before they can proceed. And the danger for the buyer is that the buyer is the one that's going to get the certification from the IRS that there was actually withholding due on that transfer because he had a non-foreign person involved in that foreclosure sale or that deed in lieu of foreclosure.
So in that case, the bank would hold if they're taking the deed in lieu or the foreclosure, the lending institution would actually be liable for the taxes. What happens when they turn around and resell it quickly?
Yeah, it doesn't apply to that transfer when the bank does it, but does apply to the transfer where they took it. Okay.
Okay. So you should be reasonably safe for your buyer to buy a foreclosure because it's already had one transfer to the bank.
Right.
Okay.
Okay, want to scroll down again a little bit, Jordan, and we'll go to the next question. Oh, so I thought there was a question there about substantial presence test, but if it's not in there, I can talk a little bit about substantial presence, because that is one of the other things that you're going to see most often in determining whether or not on those seller affidavits. There's actually a couple other things I'm going to talk about as well, but so on the seller affidavit, you're going to talk about whether or not the buyer is a U.S. resident, a U.S. citizen, green card holder. Okay, so if they don't have a green card, they can still be a U.S. person if they pass a substantial presence test. That means that they've been in the United States for a certain period of time during the last 3 years. So typically what it is, there's a mathematical formula where you calculate the number of days in a year and the number of days you were present. And that number in those 3 years has to add up to, I think it's 181. And you only get, it's weighted more for the current year, less for the second year, and less for the third year. So you can be without a green card. The only other way to be exempt from that withholding is to pass that substantial presence test. The problem you're going to run into is that some buyers, and I understand the reluctance on the buyers, because again, they're the ones that are responsible for making a determination whether or not that information is sufficient for them. But there's also some title companies that won't even rely on a substantial presence test. And the reason for that is because there's also some exemptions, because IRS has exemptions from everything, including their own exemptions. So there are some exemptions for that substantial presence test. So if you're a resident alien in the United States, but don't have a green card, you've been here for 3 years, but you're on a certain type of visa, that doesn't qualify you to pass the substantial presence test. Also, if you maintain a homestead in another country, and you consider that to be your primary homestead rather than your residence here in the United States, then that also exempts you from that substantial presence test, even if you can meet the number of qualifications. And a lot of title companies don't want to make that determination on their own. So they don't allow that substantial presence test to be presented to qualify somebody to be a US person, meaning then that they're going to hold that 15%.
Does Minnesota title allow it?
Yes, we'll do that. We will, but we have an affidavit that's signed that basically states we'll have that seller certify that they're not maintaining a homestead in another country and they don't have one of those visas. So there's another form that we add to that.
I've ran into this with students that are here for education and they're here legally and they buy something.
Right. And that's one of the visas. So there's several types of visas that are listed in the IRS regulation, and one of those are the student visas, the different types of student visas. Because again, the theory there is that they're here on a temporary basis. They're not going to be here as a US person. They're here on a temporary basis. They're maintaining a homestead somewhere else. They're just here for school. So the other thing I wanted to really emphasize is that seller affidavit, often referred to in here as the CNFS, Certification Non-Foreign Status, is an affidavit. So a lot of times you're going to have a seller that is using a power of attorney for the transaction. A power of attorney, and we get this question all the time, can the power of attorney sign the FIRPTA affidavit? No, power of attorney cannot sign a FIRPTA affidavit. Not because it's a FIRPTA affidavit. Power of attorney can never sign an affidavit for the principal in any transaction or of any nature, because an affidavit is a sworn statement of the person making the statement. So if you have an affidavit of a seller, it's a sworn statement of the seller, and it has to come from the seller. Now, an attorney, in fact, can make a sworn statement about a seller, and oftentimes you'll see that on the typical seller's affidavit, where they're certifying that they know the seller and they know that the seller lived here and those types of things. But the problem with the FIRPTA affidavit or the CNFS form is the IRS form and the forms approved by the Minnesota Land Title Association don't deal with a situation at all where the seller is not signing that form, and they haven't created a form, haven't allowed for a form. So it's not an exception that the IRS has officially accepted. Now, the problem with that is it's problematic, and I've argued this with the IRS. I've also argued it with the MLTA. There are many times where the seller is in a nursing home. They don't have the capacity to sign an affidavit. They don't have legal capacity to sign anything anymore. So they have to use a power of attorney for the transaction. So you're going to find some title companies that will not allow a substitute form. We do have a substitute form in Minnesota Title. We'll use it in limited situations. We have to have certification that that seller does in fact have a legal incapacity and cannot sign that. And then we're willing to rely on that form if the IRS questions why the seller did not sign, excuse me, did not sign that seller affidavit. Any questions on that? Because that's probably the situation you're going to see the most. That's the agent. And it's typically, it's oversight on the part of the IRS, I think, because that is a legitimate concern. You can't require somebody to sign a document when they don't have capacity to sign.
So what happens when like it's an estate and the person is actually now deceased?
Again, so they'll rely on the status of that person that was deceased. But again, it's a different form. And it'll
Okay.
also, if it can be one of two things. So if the estate itself has its own tax ID number, it'll be the estate as an entity, then it'll be looked at whether or not it's a foreign entity or not. But
Okay.
if it's not, they can also go to the personal representative and look at the status of that personal representative, whether or not they're a personal or a foreign person. And again, a lot of times it's not the closing agent that makes that certification. So in Minnesota Title, it might be a situation where we've used that extra affidavit and we explain that we've got the information that the seller doesn't have capacity to sign, but it's really we have to present to the buyer, and the buyer has to make the determination if they're willing to accept that information. Because again, it's the buyer that's going to be subject to withholding if the IRS makes the determination later that it was a withholding transaction. There are other title companies, though, that will not use a substitute form, and they'll require the buyer then to waive the FIRPTA withholding. And there's a form for that, so the buyer can actually sign a document, sign an affidavit as the buyer that he's willing to allow the transaction to close, and he'll waive any FIRPTA requirement, no affidavit on part of the seller, and roll the dice and take the risk with the IRS that it's not a withholding transaction. But in cases, Burnett Title is one of those, and makes sense. They helped with some of the MLTA forms, but they will require in a situation where you have a seller that's not going to be signing the FIRPTA affidavit. The only way to proceed for them is to have the buyer waive the FIRPTA requirements. They won't close with a substitute affidavit. I'm not calling them out on that. That's just the determination that they made, and it's a reasonable determination because there is no exceptions in the IRS. But I just point out that that's one company that does that, and there's several others.
So in real life, what I see, because I'm the broker, so when I'm reviewing files is just randomly, first off, agents don't understand it, so they tend to leave that line on the purchase agreement blank. And I always have them go back and make sure the seller completes it and everyone
Yep.
acknowledges it. And then sometimes the sellers also maybe accidentally leave it blank on the disclosures, which really throws up red flags to me when they just kind of accidentally leave both areas blank.
Right.
Is the form that the title company then has them sign with their affidavit, we don't get a copy of that. And I've asked for it in the past, and we don't get a copy because it has social security numbers on it.
Right.
Or some sort of tax ID number. Is there anything that the title company can provide at closing if we're already to that point and we still don't have acknowledgement on anything on the PA?
It's provide as far as whether or not they're a U.S. person or
whether or not FIRPTA withholding was required.
Okay, so FIRPTA holding is always going to apply to every transaction unless they're claiming one of the exemptions. So in one of the exemptions, so they have to either claim the exemption, $0 to $300,000 exemption, what the buyer has to claim, or they have to complete that seller affidavit. So it applies to every transaction. FIRPTA applies to every transaction.
Okay, and we can't get a copy of that affidavit, so agents do have to follow up and get it done.
Right.
Thank you. The other real life thing we have is you ask if someone's married. You meet them, they've got a wedding ring on. Oh yeah, this is my husband, this is my wife, and you get to closing. Oh no, we're not legally married.
So when we run into that situation either, sometimes somebody will get creative and they'll call it culturally married.
Yes.
The United States and the IRS recognizes any marriage that's considered marriage in another foreign country is considered to be married in the United States. So they'll recognize any marriage that was done outside the United States.
So these cultural marriages that are done within the United States, but there's no filing it at the courthouse, there's no marriage license application, the IRS still considers that a married couple because they've presented themselves as such.
That's correct.
Interesting.
Yep.
Thank you.
Yep. May not be a marriage for other purposes, but it's for the purposes of the IRS and their withholding requirements, they're going to take that as a valid marriage. And provide that non-titled spouse didn't an interest in the property.
Yeah, because I've literally had people show up with a wedding ring on and they claim they're not really married.
Yeah. No, I've seen some pretty creative stuff myself over the years. So, but you know, and it becomes more of an issue when you have somebody that claims they're culturally married, but they don't know where the other spouse is. You know, then you've got to track down that other spouse, and you know, and that's been difficult in a few cases. So.
That's very usual in Latino world.
Pardon me?
That's a very usual situation in the Latino world.
Yep. Yep.
I have a question. What about if the seller lies in the, you know, that they check that box and they are not really resident?
So the question then is, if anybody relied on that information, reasonable or unreasonably. So if you know that information was false, then there's going to be liability on anybody. So if you as the agent realized that information was false and you present it to the buyer and the buyer accepts that information, you as the agent could have liability. And if the buyer is aware of the information, the buyer is also going to have liability and they're going to be subject to that withholding themselves. And the IRS isn't going to go after the seller. They're going to go after the buyer and they're going to go after the agent.
Is also the broker and the title company then liable as
Right.
well?
Yep.
Real estate company?
Yes, if the agent is the agent of the broker. So if the agent was aware of it, then that knowledge is commuted to the broker as well. So the broker is then also going to be on it. But the title company, if the title company is not aware of it, nobody's mentioned it to them that it was false information, the title company could be exempt if they can prove that nobody mentioned to them that was false information. But if they are also aware of it's false information, the title company is also going to be liable or can be liable. Anybody could be liable, yeah. Anybody that had knowledge of that and presented it to the buyer and allowed the buyer then to move forward. So.
Doesn't the title company has to ask for some IDs?
Yes, they do ask for ID, and that's all that information that's on that seller affidavit that of course we can't share because it's all the seller's personal information. But yes, we do ask for that. They have to actually present their driver's license or an ID card or a green card, or in cases where they don't have that green card, they pass that substantial presence test, but they have still to present some type of ID.
Okay.
Typically a passport or something like that. So.
Okay, but my question was, I'm sorry to say it again, is what about if the seller lies and when they check the box, they say that they are residents, but they are not. But I mean, me as
Right.
an agent, I don't know, and I never ask for any paper. You know, what about if we don't know and the buyer doesn't know neither?
Yeah, if the representation of the seller is false, but it was reasonable for anybody to rely on that information, then the buyer is protected from that liability, but he's got to be able to show that reliance on that information was reasonable. And one of the things they would look at, whether or not it's reasonable, did you ask for any identification? If you didn't ask for any identification, or any verification of that information, then IRS might contest that and say, well, that wasn't a reasonable reliance. And so we're going to hold you responsible. But again, then it becomes a measure of proof at that time.
Thank you.
Was-
Thank you.
Okay.
If there's any questions in the chat.
Is there any other questions in the chat, Jordan, or?
I don't think there's any questions. I know someone asked if the handout will be shared, and that will. I'm going to send it out after
Okay.
the meeting. I'll send it out to the entire market center just so that everybody has it.
Okay, well, thank you.
Yeah. I don't know if anyone else has any other questions.
Awesome. That looks good, Jordan. Thank you so much.
Of course. Thank you guys so much for joining and teaching us about this. It was really awesome. So, and I have it recorded as well, so it'll be up on the YouTube channel. If
Perfect.
you needs to go back and rewatch any of it, and then I'll shoot out that handout to everyone.
So is there anything I need to do special to unplug my computer or just unplug it?
You are good. As soon as I end the meeting, you can just write out and you guys are all set. So if nobody else has any other questions, we'll wrap up for the morning. I think that's it.
Thanks, Jordan. Thanks, Mark.
Bye, Marta. Thank you. Have a good day.
All right. Thanks, guys.
Thank you.
Thank you.